Hi, I'm Anna Sutcliffe. I'm a partner in our Contentious Probate team here at Wright Hassel. Today I'm going to talk about the Inheritance Provision for Family and Dependants Act 1975. That is a bit of a mouthful, so I'll refer to it as the Act. What we're going to do today is a series of question and answer type points, questions that people often flag for us, hopefully to make it a bit more interesting and a bit more understandable if you think you may have a claim under this Act. This is my colleague Hollie Mills.
Hi, I'm Hollie and I'm a solicitor in the Contentious Probate team and I work closely with Anna. Following on from Anna's short introduction, we're going to be doing a Q&A on commonly asked questions, and kicking off with the first question is, what is the Act and how does it work?
So we're not talking about challenging the validity of a will. What we're talking about in respect of the Act is circumstances where certain categories of people have been either excluded or perhaps only receive a small amount in a will or under the intestacy provisions, and they're looking to make a claim for some additional provision from the estate.
Where a deceased has died domiciled in England and Wales, the Act gives the court power to make reasonable provision for people that haven't been included in a deceased estate. There are a certain category of people that do fall under that criteria, so turning to Anna, can you elaborate on the type of people that fall into that category?
So first of all, just to touch on domicile, which can be a tricky area. For our purposes today, really what we're looking at is where the deceased called home. So moving on from there, the kinds of people that can bring a claim under the Act are a spouse or civil partner, a child of the deceased, somebody who was treated as a child of the deceased, someone who was being maintained by the deceased, or someone who for the entire period of 2 years before the death was living with the deceased as husband or wife.
So now we've considered the categories of people that may be entitled to bring a claim under the Act. What is reasonable financial provision?
Great question, thanks Hollie. So in the context of a husband or wife, the court is looking at what provision is reasonable for them to receive in all of the circumstances, so not just for maintenance, and they will usually start with what is called the deemed divorce test. So what the court will do is they will look at what the scenario would be if instead of passing away the person they were getting divorced, what would the distribution be? For all of the other categories, what the court is looking at is what financial provision would be reasonable for their maintenance. So it's slightly different for spouses and civil partners who may expect to receive potentially a larger sum.
When the court is deciding whether to allow a claim, what sort of things do they take into account?
So first of all, the court has got to be satisfied that the applicant is eligible. If they are an eligible person, basically what the court is being asked to do is to conduct a balancing exercise. So the court will have regard to the pot of money, which is the estate, and it will carefully scrutinise the assets and liabilities of the applicant to see what their genuine need is. But of course, if they're taking out of that pot to give to that person, then potentially that has a detrimental impact upon the other beneficiaries. So the court has to take that into account as well. Really, the court is doing a juggling exercise to try and make sure that any determination that it makes is fair.
So once the court have taken into consideration everything that you've mentioned above, Anna, what kind of orders would the court be inclined to make?
The court has a wide-ranging flexibility. So depending on the circumstances, they could give somebody a life interest in the property, they could order for periodical payments, or they could actually give somebody a property. It's really looking at what the person's needs are and what provision can be made to adequately meet those needs, but also taking into account other beneficiaries who might be affected. So really, we're back to that juggling exercise again.
Now that we've gone through the processes of the court and on a high level discussed what the court will consider, Are there any things that we need to be aware of in terms of any timeframes if somebody wishes to bring a claim?
It is important to be aware with this type of claim that proceedings must be issued within 6 months of the grant of probate being extracted. So if you think that you have got a claim, it's wise to act quickly, because although 6 months sounds like a long time, it can pass by very quickly.
So Anna, tell us, what happens if somebody wishes to pursue a claim but those 6 months have actually lapsed?
It's not impossible to bring a claim out of time, but an application would have to be made for the court's permission. The kind of things that the court would look at in that application is, why didn't you do something earlier? If it was the case that you didn't realise, then how quickly did you act, when you became aware you should be doing something? They would look at the prospects of the claim. They'd also look at whether there was any other recourse that you had, and really, they'd be deciding whether it was fair, to allow you to bring that claim outside of the 6 months time limit.
That's been really informative. Thanks, Anna.
I hope you found that useful. If you'd like to discuss anything that we've talked about today, then please do get in touch with us. We'd love to talk to you, and keep an eye out for the next video. Thanks very much.